Excellent. All right. Can everybody hear me okay? I hope. All right, great. Well, welcome to a wonderful event this evening. I want to welcome you to NYU School of Law and to thank the Brennan Center for Justice, who is partnering with the law school in putting on this event tonight. I am Rachel Barco. I am the vice dean here, and I will be the moderator, but there's not going to be super moderation taking place here. We're going to have more of a discussion. I am joined by my colleagues, Adam Samaha, who is the Inez Milholland Professor of Civil Liberties, and Bert Newborn, the author and center of attention tonight, the Norman Dorson Professor of Civil Liberties. And we are here tonight to celebrate and talk about the publication of Bert's fantastic new book, When at Times the Mob is Swayed, A Citizen's Guide to Defending Our Republic. I think it is a must-read for anyone who is worried about the state of our country right now, and who wants to think about ways to tackle it. The book takes a close look at the pillars of our constitutional republic to see how they're holding up. On the jacket, it talks about thinking of this as a kind of stress test to see how things are doing, and finds, there's some stressors that are really calling into question how well things are holding up, but in a positive vein offers some reforms and things that we can all think about doing. So we're going to hear from Bert first about the premises of the book and some of the key ideas. But I just wanted to add how uniquely situated he is to be the author of this book. For decades, Bert has been one of the leading voices in our country about constitutional law and constitutional rights, and he comes at this question as a prolific scholar and also as an advocate who has participated in more than 200 cases in the U.S. Supreme Court. He is the former legal director of the ACLU and the founding legal director of the Brennan Center for Justice. I don't know that there is an area of constitutional law that he hasn't put his fingers on and improved in his long and wonderful career. So I think the best way to start is to have you kick this off with a, kind of an overview of the book for folks who haven't yet had a chance to read it, which they will remedy tonight. You can do it after the debate if you want to. So Bert, can you kick it off with a little overview of what we'll be talking about?
Sure. Thanks, Rachel, and thanks for the lovely introduction. She's right. There isn't a piece of constitutional law that doesn't have my gummy fingerprints on it, but not necessarily for the better. I have worked on lots of cases, but I've lost lots of cases and won some as well. So let me start by just saying a personal word, that it's lovely to be here. This is my 48th year on the NYU faculty. And I find it remarkable to look back on the progress of the school, to having it be one of the great intellectual sites of the law in the world, and how wonderful it's been to be on that ride. And just to say to you tonight, on a very personal level, that I miss Norman Dorson and very much wish that he were with us tonight. So the purpose of the book, as Rachel points out, is to give a stress test to our institutions. I mean, when you get my age, stress tests are something to think about a lot. So it's a stress test for American institutions. The reason that I think it was important and is important to administer a stress test like this at this time is that the institutions are under a kind of pressure that I never would have dreamed earlier in my career that I would see. And as those of you who have looked at the book, and those of you who may have read it, there's the second chapter, chapter 2, which is the chapter that nobody gets past. They warned me that if I put it in there, nobody would get past. But the second chapter is the chapter where I do a serious comparison between Trump's rhetoric and the rhetoric that Hitler used in 1933 to 1936 in Weimar Germany. And I want to clarify something, because it's very important, because people get to that point and they don't go any further, and they want to talk about Trump and Hitler and Trump and Hitler and Trump and Hitler. That's not what this book is about. The reason that I thought it was important to write the book was that the kind of rhetoric that Trump is using, which is very similar to the kind of rhetoric that Hitler used in 33 to 36, has the capacity to put immense stress on liberal democratic institutions. It's a rhetoric of divisiveness, it's a rhetoric of fear, it's a rhetoric of anxiety, it's a rhetoric of anger, and that it has the capacity to erode and essentially corrupt the institutions of liberal democracy that depend upon a more tolerant and a calmer approach to things. I am not and do not compare Trump to Hitler. I think it would be odious to trivialize the horror of what Hitler did, to suggest that anything that Trump has done or is even talking about doing comes close to that level of odiousness. And it trivializes Hitler to be able to just use him in an ordinary comparative sense. But I think it is legitimate to point out that the rhetoric is the same. And that the rhetoric is what Chapter 2 is all about. Now, assume that I'm right, that there's lots of tough, very difficult rhetoric floating out there, and that it is particularly parallel to much of the rhetoric under Weimar. What are our institutions? How are they structured to deal with it? And I try in the book to divide the institutions into two kinds of categories. I call them the internal brakes, which are the brakes that democracy itself should bring into play to control this type of behavior, and the external brakes, which are brakes that outside people will bring in to do that. Now, the internal brakes are the founders' development of a democracy that has relatively large constituencies made up of very diverse people, where it's very hard for a single group to capture a constituency and capture the democracy. And the theory, and that's why the founders have large congressional districts. It's why we have large Senate districts. They thought that the bigger the district, the harder it is for a small group of people to capture it politically and to abuse their opponents. We've got three problems with the internal brakes. The first one is the fact that the Senate does not actually provide us with anything remotely resembling democratic representation. The Senate is badly distorted, and it's badly distorted rural, urban, and voter of color, white. So for example, Wyoming, with 600,000 people, at 97% of whom are white, elects 2 senators. California, with 40 million people of enormous diversity, also elects 2 senators. That's a 65-to-1 breakdown in the idea of one person, one vote. So we go into our democratic system knowing that there's a tilt, and that there's a very difficult tilt based on both race and a rural-urban split. That's made a little worse because the Electoral College, the representation in the Electoral College is key to the Senate. You get as many electors as you have senators and representatives. Well, the representatives are fine because they're allocated by population. But if the Senate is not allocated by population, it means that the same small rural states that have greater disproportionate power in the Senate also have greater disproportionate power to elect the president. And they happen to be white rural states. The third is partisan gerrymandering. Partisan gerrymandering, at least under a Republican administration, tries very hard to increase the power of the rural districts vis-a-vis the urban districts, and to tilt the voting situation where the voters in the urban districts are packed into a few urban districts that they win by overwhelming majorities, while the rest of them are spread out over the state in ways where they're outvoted by the rural voters. And that's what they did in North Carolina. That's why North Carolina, which is a 50-50 state, reliably sends a congressional delegation to Washington that's 10-3 Republican. And one of the gerrymandered districts was North Carolina 9, that was won by the Republican yesterday, not surprisingly, because it is a gerrymandered district, tailor-made to make sure that the Republican wins. So we start with those three problems. And those three problems are difficult, and I would say, therefore, there is a kind of, we suffer, the democratic process suffers from a kind of weak racist fever because white America and rural America are disproportionately represented. And with all of the problems that we'll have in creating disenchantment, in creating anger, in not creating fair representation, but I don't think that's what's going to kill us. In the book, I have some workarounds. There's no way to fix the Senate, really. We could fix the partisan gerrymandering. The Supreme Court wouldn't, but the people will. We will get around the partisan gerrymandering issue. And the Electoral College, I'm not sure we can fix it. I think we just have to learn to live with it. But what's killing us as a democracy is low voter turnout. And I don't care who the voters vote for. I don't care who the voters vote for. Because if you think of the founders' theory was that if you have large constituencies, and large varied constituencies, it is very difficult for a single ideological grouping or a single racial or religious grouping to capture the polity. Because there are so many voters that you have to really get a lot of votes. Now, if people don't vote, then those same districts become subject to capture. So, for example, if 30% of the people turn out to vote in a gubernatorial election, or as in North Carolina yesterday, about 35% turn out to vote in the election, that means that yesterday in North Carolina, a shade over 18% of that district now controls the district. That's exactly what the founders were afraid of. That's a number subject to capture. That's a small enough number subject to capture. And once you capture, then you try to keep yourself in office. So it seems to me that for me at least, the way to help the democratic brakes, the internal brakes, is to do everything we possibly can to increase voter turnout. And I have some funny suggestions to do it, some real suggestions, but I end up in an interesting place. I end up in mandatory voting. I end up by suggesting that Australia's got it right. They have turnouts between 97 and 99%. And they do it because there's a mild civil sanction if you don't vote. And my sense is if people don't vote, they are not only penalizing themselves, but they're penalizing the rest of us by creating low voter turnout situations that are capable of partisan capture, and they're frustrating the genius of the American Constitution. Now, just a quick word about the external brakes. The external brakes are the Supreme Court. That's supposed to be judicial review. That's people outside the system who stop the train before it hurts anybody by recognizing that it's unconstitutional. Now, I've made my career playing with the external brakes. I mean, urging justices to go one way or the other. But the one thing I'm sure of, I was sure of it when I was winning, and I'm sure of it now that when I'm losing, it is folly to believe that there is some sort of machine in the sky that keeps us free, that it runs by itself, and that there is some sort of self-perpetuating machine where the Supreme Court will get signals and use those signals to protect us. It's coming from inside the Supreme Court. Those signals are generated by the justices themselves. Now, they generate them usually, I think, in an honest, intellectually admirable way. They are not partisans. I don't think any one of the 9 justices thinks of themselves as partisan or acts as partisan, but they're human beings and they have values. And those values break ties in close cases. So one of the things I argued is that in many of the cases I've argued over the years, the legal issues have been a tie. Basically a tie, plausible arguments on both sides. Each lawyer screams and yells that their argument is better, but that's what we get paid to do. But the truth is, if you were objective, they're pretty close to a tie. Purely legal, formal arguments. What breaks them are the values that the arguments advance. So that if you have an argument that advances autonomy, like a First Amendment argument, the right to say whatever you want, individual autonomy, that's a value that resonates with the justices. And they think, great, that's a really, that's an interesting legal argument. It's plausible, maybe not overwhelming, but it's plausible, and it advances autonomy. I love it, so I'm going to endorse the argument. There's also arguments that advance equality. The justices love that too. But what happens when you can't have both? What happens when you have a case where there is tension between autonomy and equality, like hate speech, like campaign finance reform, like affirmative action? There, you have to hierarchically rank the values, decide whether autonomy is more important than equality or whether equality is more important than autonomy. Over the years, Republican justices, acting decently and honestly and with intellectual rigor, have tended to rank autonomy more important than equality. And Democratic justices have tended over the years to give greater weight to equality than their Republican colleagues. And that much of constitutional law can be understood as the interplay of those arguments. And so when we get mad or angry or look to the Supreme Court for guidance, we have to remember that they're human beings being driven by values, and that they are honest and doing what they can, but that for us to expect that our freedoms will be perennially protected by this group of people in Washington would be a terrible mistake. The only way our freedoms will be protected, the only way, is if we protect them. And if we protect them through the ballot, and we protect them through the processes of democracy, there is no deus ex machina waiting in the sky to come down and protect us if we're not worthy of the freedoms that we hope to engage. So.
Excellent. Thank you, Bert. So I think what we're going to do is Adam and I are going to take turns. It doesn't have to be in order, asking some questions, and I'll open it up for you all to ask questions in a little bit after we have our discussion first. And so I'm going to...
This is a tag team match.
Yes.
It's 2 against 1.
So Adam, you want to kick it off?
Hey, thanks for inviting me. It's good to see you.
Thanks, Adam. I appreciate it.
So one of the highlights of the book for me is far beyond chapter 2. Probably not a shared experience much, but it's when you talk about the fact that there are a wide range of fairly easy legal questions for skilled lawyers, that there's really a wide area of agreement there, and I think that's an important reminder for people. And it also suggested a broader question in my mind about agreement, and it's connected to constitutional values, the values you think associated with our Constitution. And I'm wondering if that book is mainly about the litigated Constitution. It is some about non-litigated issues for sure, such as the structure of the Senate. But I wanted to ask about some of those cross-cutting values. So a number of them that you highlight in the book, and rightly so, have a feature of zero sum and the aversion of catastrophe. And that's obviously important. There are many issues where we can't all win. And so that's the theme of there's a left and a right, or a red and a blue way of understanding rights. And then catastrophe avoidance, importantly, about avoiding concentrations of power. So I get that, but I'm wondering if there's another set of values not foregrounded here that are constitutional at their root, and they have a quality of collaboration and even experimentation for mutual gain. Now, one possibility is that that's not a fair rendering of what our Constitution represents. Another is it is part of it, but it's not really part of the litigated Constitution, the place where people fight about. And so maybe it's that area where lawyers can agree once they think it out, but it may not be especially important. But in light of divisions that we have, I'm wondering if you think that our Constitution actually does reflect is importantly about collaboration and not so much disagreement, and for mutual gain and not for zero sum.
Well, that's a great observation. I mean, I tend to think of the world from someone who is thinking about it from inside the courtroom out. I mean, since so much of my career has been a career of a litigator, I tend to think of the world as a litigated institution. But Adam is right, of course, in pointing out that only a small slice of our experience is ever shaped by litigation. So, for example, there are two ways that I think he's clearly right. One, there's something that I call the psychic Constitution, not the written Constitution, not the stuff that's written down, but the stuff that's in all our heads about how things are supposed to work. And one of the, for me, scary parts of the Trump era has been the constant smashing of those psychological barriers, those assumptions about, the pundits call them norms, but whatever it is in the back of our head that makes us think about how things are supposed to work. That's hugely important, and maybe more important than the written Constitution, more important than the litigated Constitution. But then the second point that Adam makes that I think is so important, and that's that the world is not necessarily a zero-sum game. Litigation is a zero-sum game. One guy wins, one guy loses. But legislation doesn't have to be a zero-sum game, although sometimes we make it out to be that way. And certainly thinking about politics and thinking about the Constitution itself doesn't have to be a zero-sum game. We could think of a way to try to reach sweet spots, a sweet spot where each side gets what it needs. Any good negotiator, not our president, but a real negotiator who negotiates, he doesn't bluster and bully. A really good negotiator tries to identify the point at which each side can enjoy the maximum of what it really needs, and then try to reach that sweet spot so that each side walks away from the table thinking they've got what, you can't always get what you want, but if you try sometime, you just might find you get what you need. And you can do that through really good negotiation, and really good politics perhaps should be thought of as encouraging that kind of activity. So I welcome the question, and I tell you now, that's my next book. In 3 years, we're all going to meet here to talk about that. Alavai.
All right, well, then I'll be the negative side of this, which is, in a realm of party politics, I guess the part of the book and what you said tonight that I want to question is this idea that if we just have voter turnout, that will solve things because it'll represent lots of diverse interests and therefore they'll compete with each other. But, the framers weren't thinking the party politics that we have today. They weren't thinking about the tribal allegiances that people have to the Republican or the Democratic Party. And so those parties end up being the amalgamation of different interests that people are willing to sacrifice some for others. And so I guess I'd like to hear more about why you think we could have better outcomes with turnout if it turns out that you could have lots of turnout, but given what you just said about the Electoral College and what you just said about the Senate and what you just said about gerrymandering, if that all is pointing in favor of Republican wins and we have tribal party politics, I actually don't see that many areas where there's any kind of compromise at all, because that's just not what partisan politics look like.
So let me take that on head on, because obviously that's a very important observation. The observation that so much of my chapter 3 is all about how, gee, if only we could get more people voting, what a great place this could be again. And I claim, and I don't even have my fingers crossed when I make the claim, that I'm not saying I want my people voting, that I want progressives voting. I want everybody voting, because the more people who vote, the better it is. And Rachel says that's based on a pre-political party assumption that political parties have now organized ourselves, we've organized ourselves through political parties into two tribes. With strong ideological views that are so inconsistent with each other that we look at different television stations, we read different newspapers, we see different worlds. We're talking past each other, and there just isn't any room for compromise. Politics is a zero-sum game. We can't get back to Adam's world where we can work toward collaboration and compromise. That the political parties have, in some sense, rendered it impossible to do it. She's right, of course, that the founders didn't think about political parties. They didn't anticipate them. In fact, they hated them. They called them factions and thought that they were beneath the dignity of people who would live in a democracy. But it quickly turned out that you can't run a complicated democracy without a coordinating mechanism. And the coordinating mechanism is political parties. It coordinates activities. You certainly don't want to have the government do it. They won't do it well or fairly. So it's better to do it through these individual political parties. And until very recently, it all worked beautifully. Why? Because the political parties were big tents. They were great big tents within which there were enormously diverse interests that didn't necessarily line up in any kind of ideological way. So that when I was a kid, conservative Democrats were considerably to the right of progressive Republicans. And there was a real, and so within the parties themselves, the founders' operation worked. No one group in the party could dominate the rest, and therefore it was essentially a politics of cooperation, collaboration, coordination, and shifting alliances, which is very close to what the founders imagined. I remember as a young person then, you don't get what you wish for. I remember writing when I was just out of law school, writing a piece bemoaning the fact that the parties didn't mean anything. That it didn't mean anything to be a Democrat or it didn't mean anything to be a Republican because they were all things to all people. I said, what we really need in this country are parties that have an ideological basis so that people can make choices and be able to decide what's going to happen. And so that came true in spades. What we have now is we have these intensely tribal parties in which people don't even talk to each other. They shout at each other because they don't think they share anything. But I don't think that's inevitable. I don't think it's inevitable. I think that the reality is that if you can get underneath the screaming and underneath the cable television and underneath the personalities, the issues that we as a people have to decide are issues that don't necessarily line up that way. Deciding exactly what kind of healthcare system will really work, deciding what a social security system should look like, deciding what kind of a tax system will encourage individuals to produce but nevertheless produce enough income so that the country can take care of its other needs. And most importantly, as Peter Schuck has written so persuasively about, we can come together as a people and rationally talk about what kind of immigration policy we want. It's not automatically rendered ideological. These are all issues that people are capable of discussing rationally if we could only put ourselves into a position where rational discussion is possible. The reason why, one of the reasons, I don't say it's the only reason, one of the reasons, Rachel, why rational discussion is not possible is because when so few people vote, a very small group in the electorate can capture the power, and that small group can be organized on ideological lines. So it isn't necessarily the fact that the parties have become tribal, it's the small groups that control the parties. You know, in primary elections, it's not uncommon in the United States to have a primary election where you have a 10% turnout or a 14% turnout. Do the math. The winner of that primary has to get 6% if it's a 10%, or 7%, just over 7% if it's a 14%. That's a small group of ideologically driven people who, because nobody's voting, get to take over the hall and run it. Now, if everybody were voting, I don't think they would replicate the ideological fervor of the small group of people that we've empowered to take it over. So I think where we may differ is an empirical prediction. I don't think the two parties from the ground up are made up of a uniform group of ideologues who hate each other. What I do think is at the base of each party, there is a group of ideologues that hate each other. And the way we're structured now, that small group is encouraged to capture both the party and the polity. And the best antidote to it is to get more people voting. And if you get more people voting, then you drown the ideologues in a greater centrist mass where it's much harder for them to take over. At least that's my hope. You don't do what I've done for 50 years without being a romantic. So I acknowledge that that's a romantic view of democracy. But I ask then, what's the alternative? I mean, the alternative can't be a kind of arms race where each side tries to beat the other by just a little bit and then takes power and slams the other as hard as they can. That's a future that it's not going to be worth living in for us. So we have to escape it. And I think we can escape it if we can just get enough people voting to get over that critical mass.
Hey, I agree that the type of partisan divide we have now is not inevitable. That's got to be right. And I think it's not just your hopefulness. There's evidence to indicate, better evidence that the political elites are divided more than everyone else. And it's not hard to ask a polling question to foreground divisions. And there's some scattered evidence that if you can get people to pay just a little bit of attention for a minute or so on policy details, they don't display the same kinds of divisions. There's still a problem, though, both rhetorically and structurally, about enhancing participation. So just a quick two-pronged question for you then. So one is, do you think it's better or worse to have much of these divided debates in constitutional terms, or is that actually an instigator of division? Different people have different views about this. And then a real specific law-based question, and that is on mandatory voting. I do think that it's a really interesting option, should be thought about. I'm wondering, though, as a proponent of a free speech model for analyzing voting rights and electoral process, whether we could have mandatory voting, wouldn't that just be a form of compelled speech you'd have to rule out by adopting one of your doctrinal propositions?
Let me do the second one first, because there's a funny story. Adam's second question, that how can I, who spent a lifetime arguing in favor of free speech and making your own autonomous political choices, how do I wake up one day and say, I'm coming with a hammer to make you vote? The state is coming to make you vote. And there's this funny story. One of the last board meetings of the ACLU that I attended before I left. I was legal director in the Reagan years, but then was a active ACLU person for years. And one of the last board meetings, I raised the question of mandatory voting. And one of the really funny board members from Massachusetts got up and said, I have a motion. I want the aliens to give us back the real Bert Newborn. Because this guy has been beamed down, and he's not the real Bert Newborn. I take that argument seriously. I mean, this is a serious argument. You don't force people to do things they don't want. So I should really amend what I said. It's not mandatory voting I'm talking about. It's opt-out voting versus opt-in. We run a system of voting now in the country that is an opt-in system of voting. You have to overcome a relatively minor series of hurdles. Through much of our country, country's past, the hurdles were huge. And one of the great, I think, triumphs of the Supreme Court during my years of practice before it was the elimination of those hurdles, one after the other. We got rid of the legal hurdles to voting. Now, the Republicans are trying to bring them back in the form of IDs and difficult purging statutes. But the truth is, the hurdles are low. Hurdles are very low, but you have to go over them in order to vote. So it's an opt-in system of voting. You have to choose to opt in. I would make it a little different. I would flip the initial burden. I would say, look, you have to vote unless you carry out a very modest form of opt-out. You file a statement that you don't want to vote. You essentially demand conscientious objector status and don't have to vote because you don't want to. I think if we did that, we would ease the pressure on the libertarian model. And it works. You know why I know it works? 401k plans. 401k plans are like minting money. I mean, they are a great deal. If you put your money in the 401k plan, it grows tax deferred. It is a terrific deal for building retirement income. Now, if you take a look at the economic statistics in the country, employees who are who are entitled to 401k plans that have matching payments by their employers and that grow through a tax-deferred basis. If you do it on an opt-in basis, only 37% of American workers opt in to 401k plans. If you change the dynamic to say that you're in the 401k plan and will withhold money from it, unless you say you don't want to be in it, the number goes up to 68%. So that the difference between opting in and opting out, and any lawyer who will tell you that. I mean, class action notices, for example. If I send a notice to you that says I would like you to be part of my class, if you had to opt into that class, there would be no such thing as class actions because nobody would, because the number of people who would opt in would be too small. But if I say if you opt out, you can leave, then that's tolerable because the inertial burden is enormous. If we put the inertial burden on voting instead of on not voting, overnight we would increase turnout by 40%. Overnight. And at no cost. And without, I think, much of a tension on people's conscience. So that's the way I'd answer the second question. Now I will tell you how old I am. I forgot the first question.
Whether you think constitutionalizing these debates is more or less divisive. Different people have different feelings about it.
Yeah, I think the reason I forgot it is because it bothers me. He's right. Adam is right. I don't like the idea that de Tocqueville said it first. He said that so many things in the American political structure that would ordinarily in Europe be fought out as a political issue in the United States get constitutionalized. It's places like this that do it. We produce very good lawyers, and they manage to make arguments. But I think it's unhealthy. It's unhealthy for a democracy to constitutionalize too much, to assume that a group of Platonic guardians is going to come down with the right answer in too many issues. There are fundamental issues, free speech issues, equality issues, that I wouldn't give an inch on, and I would insist that judicial review be powerful in those issues. But I can understand an argument that says that we're better resolving our disputes through democratic means than giving it to the Supreme Court. But I would never accept that argument if what it does is condemn a weak person to always losing in the democratic process. When the democratic process fails to adequately take note of the needs of the weak, it's at that point that you desperately need judicial review.
So I'm going to pick up on that to ask you about increased voter turnout, and as voters think about some of the things that you're talking about, one thing that always strikes me is that Republican voters understand the importance of the Supreme Court in our society, and it is actually a voter turnout issue for Republicans. I mean, they get people out to vote thinking about vacant seats on the Supreme Court. And I've always been surprised that Democratic voters aren't the flip side of that. They even, the last election, people talked about Citizens United. They talked about Supreme Court cases. We had some of that idea of constitutionalizing politics, and it did not mobilize voters in the same way on the Democratic side as the Republican side. And even now, with all the, it's hard to keep track of all the news, but there are 150 life tenured judges in as part of the Trump administration. They will be here for the rest of my life.
Every single one of them is ruled against me.
Yeah, and I think the stakes of the court, that's what the Republican Party has successfully gotten through. Maybe other parts of the agenda have stalled, but they have been a machine when it comes to the courts and the judiciary, and the Democrats have not been as successful. And so I am kind of curious to get your thoughts on where that fits into your model of reform, because it seems like that is actually a mismatch between the parties and maybe even just the public voting for the parties in terms of how they view the court in our society.
Yeah, well, it's a great question, Rachel. I mean, most of the time, up until very recently, we wouldn't have been having this discussion. It would have been considered to be an illegitimate discussion because the argument would have been that Supreme Court justices operate outside of politics, that there is no such thing as a Democratic Supreme Court justice or a Republican Supreme Court justice. Partisan labels, you have no right putting partisan labels, and that the beauty of the process is that it operated in such a nonpartisan way. And it's only recently, it's maybe since Bush v. Gore, maybe since the tribalization of the country, has undergone so much more intensity, that people pay much more attention to the fact that Democratic justices tend to vote one way and Republican justices tend to vote the other way. Even though I believe it's not partisan, but it's values that are making them do it. So it's healthy that we're having this discussion because it's always been this way and it's been swept under the rug for too long. So now let's get it out into the middle of the room and talk about what we can do with it. From just a descriptive standpoint, to answer your question about why Republicans are so much better at this than Democrats, I don't think it's all Republicans. I think what they've done is managed to galvanize the evangelical base of their party to recognize that certain things the Supreme Court is doing is so central to what their core beliefs are as a people, that it is the single most important thing they can do is to be able to get the court to be predictable for them. That's why you have this remarkable spectacle of people who claim to be deeply moral people, who care deeply about marriage and raising children right and not using bad language and not abusing sex, jumping as loud as they can at Trump rallies in favor of a man who spits on every value that they claim is important. And the answer is they're willing to make a pact with the devil, because that pact with the devil gets them the Supreme Court, which gets them the really important values that they think are necessary for the society. And I think if we got them in this room in a candid way, many of the evangelical leaders would say exactly that. Of course we think he's a terrible man, but he's a terrible man who is delivering something that we desperately need, and the Republican Party is the engine by which we get it. Now, why don't Democrats, have the same sense of urgency? Well, once they did. The early burst of women voting was essentially reproductive freedom. That women realized that their reproductive freedom depended, in some sense, on the makeup of the Supreme Court. And the Democrats galvanized that vote, and there's still the huge gender gap in American politics, I think, is ultimately traceable to that issue, to the fact that it's an issue of reproductive freedom. Now, interestingly enough, when we all fell asleep and thought everything was safely there because the Deus Ex Machina in the sky was protecting all of our rights, we all fell asleep and the voting went down. And I think one of the reasons we will never see Roe v. Wade overturned, is that John Roberts knows that the day he overturns Roe v. Wade, he turns American women into the same force that the evangelicals are now, and that they will vote in overwhelming numbers to get the court back. And so instead of overturning Roe v. Wade, what you're going to see is they're going to erode it from underneath in a kind of stealth way that will take away the rights of poor women, but never in a way sufficiently obvious or sufficiently widespread to galvanize the women's vote the way it once was.
Well, yeah, on judicial review then, what, if any, is the affirmative case for the left supporting constitutional judicial review? Because I think descriptively, you're pretty much right, which is if you just go by left-right spectrum, the right lean of the court has quite outweighed the left lean. And so I can think of some sort of defensive crouch justifications like, well, you can't unilaterally disarm, or, you know, we don't actually care, it's just an outgrowth of politics anyway. But is there an affirmative case from the left? Is it some sort of precedents that can't be budged that are just so important that the left ought to be willing to take systematic losses over time? And then just a tag-along question for that is you mentioned the alteration of size of the court at one point in the book. And I'm wondering on that if there are any circumstances you can envision in which you would support a change in the size of the court.
Again, two hard questions. You know, historically, judicial review has not been a left issue. If you look in the 30s and the history of judicial review, the left always looked at courts suspiciously. Courts were the place where the rich got their protection. Courts were an elitist group of people drawn from a particular social strata, pledged to enforce laws that were made through processes that would help the wealthy continue to subordinate the poor. That was the story of judicial review that I grew up with as a young kid in New York, as a left-wing kid in New York. I was told, never trust the courts. Don't trust the courts. They'll lead you into a dead end. And that's why no judicial review in France. That's why no judicial review in England. No judicial review in Germany. It's because the left-wing parties wouldn't let it happen in those years. And then came this remarkable event, the Warren Court. And the question is, was the Warren Court a one-time strange aberration in which a system of prophetic justices called a nation to be better than it had been? And the nation listened, and it helped get us out of the trough that we were in of refusing to acknowledge that we even had a racial issue, and legal norms that imposed racial discrimination. And then watching the court respond to McCarthyism and begin to impose really serious free speech protections, and then seeing the court sweep away all of the restrictions to voting, and then seeing the court acknowledge the Equal Protection Clause and protect discrete and insular minorities in significant ways, people of color, women, gays, the disabled, watching the court as an engine of reinforcing the power of people who were systematically outvoted at the polls, struck a number of us as a remarkable event. I saw judicial review very differently when I watched. I mean, Brown versus the Board of Education just changed my entire idea about what a court could be, that it didn't have to be a reinforcement of the status quo. It could be an engine for breaking the status quo on behalf of the weak. And that's been what has that's been my philosophy of being a lawyer my entire life. That the court could be used as a vehicle to assist groups that simply lacked the power to defend themselves in the rough and tumble of the democratic process, and to protect those groups through the imposition of rules. Now, as Adam quite correctly argues, the Warren Court is gone. I can give you the day that it went. The Warren Court died on January 7th, 1972. It died on January 7th, 1972, when Lewis Powell took office and the Democrats lost control of the court. Now, when you think of the Supreme Court as an institution, it's a remarkably stable political institution. Republicans controlled the court from 1865 to 1937. There was a Republican majority on the court. It didn't make much difference in those days as far as race went, because Republicans and Democrats were equally terrible. And only John Marshall Harlan was the only one who spoke up in those years. But it was, that's what brought us the idea of substantive due process. That's why they struck down minimum wages. That's why they struck down maximum hours. That's why they struck down health and safety, because they were violations of the employer's autonomy. And the Republican justices went down the line for autonomy and said, it's too bad that the equality of these people is being hurt, but autonomy is more important. And now, and then when the Republicans, the Democrats controlled the court from 1937 to 1972. And in 1972, the Republicans took back control, and the Democrats have never controlled it since. They had a chance in the last days of the Obama administration, but the Republicans would not allow a vote on the fifth Democratic justice. So there has not been a Democratic majority on the court since 1972. And if you watch the jurisprudence of the court evolve over that time, what you see is you see a jurisprudence of autonomy. Remarkable autonomy, more and more and more human freedom, freedom to be religious, freedom to, which is great, you know, and less and less and less equality. Occasional bursts of equality, but less and less. And so that the question that a lefty like me has to ask now is, if I have to face a future where I am doomed to have to continue to argue to justices that will not take equality arguments seriously, do I give up on the institution? Do I say that the left was right back in the 1930s? And the answer is, I don't. I don't. I don't for two reasons. One, Adam has alluded to. In the years that it was possible to make real progress on equality, precedent after precedent was embedded in the law. And the one thing lawyers and justices do well is enforce precedent. They don't overturn it, even when they think it was wrong. That's the reason Roe has lasted as long. It's lasted basically on stare decisis. So that you don't want to turn your back on the existence of this wonderful body of law that does protect people. And so I would not weaken the institution, because the institution is committed to protecting that. And my hope is, eventually, maybe the control of the court will shift, but that's a long way off. But it's possible that the control of the court will shift. But I would not give up on the court.
All right, so on that note, we can open it up for questions from the audience. There is a microphone in the back there, up that little stairwell, if people have questions and want to use that to ask their questions.
Oh, while you're doing that, Adam asked me another question. Would I ever consider changing the numbers on the court? I wouldn't necessarily consider changing the numbers, but I do think that there's an interesting proposal to term limit them. In other words, to have each justice serve for 18 years and then go back to a lower court. It wouldn't have to leave the judiciary, but serve as a Supreme Court justice for 18 years on a rotating basis, so that every president gets 2 appointments. And that seems to me, it would lessen the randomness of the court. You know, I feel like a ghoul on a death watch sometimes, thinking about the Supreme Court. Who's going to die? Who's going to then have a random ability to control the court? Nixon got 4 appointments in one term, randomly, in large part because the Democrats, talk about the Democrats, the Democrats with 60 some odd senators in the Senate were unable to orchestrate the succession from the resignation of Earl Warren. Warren resigned in 1968 to give Johnson time to appoint a justice. He didn't want Nixon to have to do it. So he resigned early, he gave him a year, and they blew it. They appointed Fortas, and the wheels came off of the Fortas nomination, and that wound up giving Nixon two appointments that he didn't think he would have, plus the 2 that he got because people died. Those 4 appointments swung the court in a conservative way, and I think may have been the single most important of political events of the 20th century. If you go down, I list 25 cases in my book that were decided 5-4, that would have come out the other way if the Democrats had managed to get the successor to Earl Warren confirmed. So I don't want to continue to go through that kind of randomness. So the idea of an 18-year term with each president getting an orderly 2 votes, it might take some of the steam out of the people's craziness about voting for president only because they want to control the Supreme Court, because they'll know that everybody gets their 2 votes, two appointments.
Did you have a question?
Thank you. This is just fantastic. I really appreciate all of your thoughts. I'm interested in whether you think public finance of campaigns would be the 4th, or could be a 4th break, or however you want to phrase it.
Great question. I don't think, I said that the best way that we could get more people voting is if people thought that voting mattered. The way most people don't vote now, not because somebody is stopping them, not because they're ignorant or they're not worthy of voting, but because they don't think it makes a difference. They're cynical about it. They think they're better off going to Walmart's for the sale than they are going down to the voting place. And until we persuade people that's not true, we're not going to get large numbers of additional people doing it. And I think one way to do it is to reintroduce competitive elections. You know, you got to be crazy to take, if I'm in a gerrymandered district and Walmart's having a sale, you got to be nuts to go vote. And it's a remarkable tribute to the commitment that many Americans have in democracy, that we actually do it, that we go through this ritual knowing that it doesn't make any difference. That we're not exercising power, we're exercising some sort of pagan ritual in which we go and press levers. But it's wonderful because it's a ritual that reinforces our dignity and reinforces our commitment to self-government. Now, if we had competitive elections, again, where it really makes a difference, then I think you'd get turnout. There would be a natural reason to turn out. And then the second way to do it is we've got to take the idea that only the rich have the capacity to make a difference. That money talks and ordinary people don't have any influence because the rich set the agenda and the rich decide who is going to win the election. I think that's an overstatement, but many people believe it. And until we can get people's heads, talk about the psychic constitution, until we can introduce into the psychic constitution the idea that voting matters and that your vote really matters, more than just a symbolic event, it's an exercise in power. If we could do that, then you'd get people running over each other to vote. You wouldn't need all of these campaigns. People would want to vote. But doing that, we have to increase the perceived value of voting by making elections competitive and by taking the big money out, and public funding is the way to do it.
Next question.
Along the lines of voting, one of the things you mentioned earlier was your opt-in, semi-mandatory version of voting. One issue in voting right now is the lack of informed voters, and with the potential 40% increase of people voting overnight, as you mentioned, do you think that, along with that increase, the increase in what would presumably be a decent amount of people who are also uninformed, do you think that would also be a potential problem for the Republic in general?
Well, you know, I get paid to be a teacher, so I'm not supposed to be in favor of ignorance. So I mean, an ignorant voter, an uninformed voter, is not as good as an informed voter. But the vote is not a test. An election is not a test. There isn't a right answer that you're supposed to get on an election. An election is an expression of self-interest and what will advance your needs. And you can be uninformed about the intricacies of healthcare and know about which candidate is going to do a better job in trying to meet your needs. So one of the, you know, for years I litigated literacy test requirements. And the argument was always, oh, well, we need a literacy test because we need an informed voter. And my response to that is, yeah, it would be nice. The more they know, the better, and we should really do that. But you cannot say that you can't vote because you're too dumb. That is absolutely off the off the map. Everybody is entitled to vote because everybody has human dignity, and everybody is entitled to express their wishes and needs. And nobody, no matter how many college degrees they have, and no matter how smart they are, has the right to say, you don't know enough to vote. And so I reject the idea of the problem of the uninformed electorate. The problem is the non-voting electorate. And if we can get them in there, they know what's good for them better than all of the pundits who tell them they're too stupid to vote.
Excuse me, we now have a decision, I think out of the 10th Circuit, which holds that presidential electors are not bound by the vote in the state.
Yeah, the
where they
faithless
come.
elector issue, yeah.
So, a couple of questions there. First of all, do you think that, can you hear me?
No, it's not that. It's just a light in my
Oh,
eyes.
I'm sorry.
You guys are at real risk. The light has been in my eyes now for almost an hour. I'm about to confess. I'm going to tell you everything.
Well, I'm glad that I'm the one that's doing the interrogation. So 2 questions on that. First of all, do you think it's going to get up to the Supreme Court, and what do you think their decision would be vis-a-vis the circuit court ruling? And 2, if it does get to the court and they do affirm the decision, how does that come into play with regard to your ideas about universal voting and increasing the number of people? If the presidential electors, at least in presidential elections, are not going to be bound by the vote of the people, what does that say for our democracy in that sense?
Yeah, it's a good question. I actually think it's more of a theoretical question than a practical question. There's always been, I mean, forever, and there's been an argument about whether, you know the way it works. The Electoral College, you don't vote directly for the president. You vote for a slate of electors who are pledged to support one of the 2 candidates, or any of the candidates that are going. But you don't vote for the candidate themselves. You vote for the electors pledged to the candidate. The electors then meet and cast their votes. Now, what happens when an elector says, oops, I've changed my mind. I know I was pledged to support this guy, but I don't think he can do it, and I'm going to vote for somebody else. And there were a number of, I think there were 4 in the last election that indicated that that's what they were going to do. I can't remember how many of them actually pulled the trigger and voted for somebody else, but one of them was in Colorado, and that's why the case comes up in the 10th Circuit. And so the question is, having pledged yourself on the ballot to vote for a particular candidate, are you then free to walk away? Are you free to say, I've chosen not to? And the 10th Circuit said yes. 10th Circuit said the original structure is to elect autonomous people who are going to meet in the Electoral College and choose who the president is going to be. And they're not forced to vote for anybody. They have to exercise their own autonomy. Now, as a practical matter, nobody gets on that slate unless the political leaders in the state have made very sure that they are reliable people who are going to vote for the candidate. I mean, you don't just stand on a corner and say, "Would you like to be an elector?" They are recruited from the heart of the political class. So the likelihood of large numbers of people ever doing this, I think, is very, very rare. But as a theoretical matter, I think the 10th Circuit's right. I don't think you can look at the original drafting of the Electoral College and come out any other way but to say that the founders thought that they were not having a direct election of the president, that they were going through a kind of indirect election where some really smart people were going to be elected as electors, and they were going to choose the president. And that therefore they have the right to do this. I think it highlights the fact that if we could, we should get rid of the Electoral College. We can't get rid of the Senate because, well, gee, that's a great idea. Why didn't I think of that? We can't get rid of the voting disproportion in the Senate because there are 3 things in the Constitution that can't be amended. There are only 3 things that are listed in the Constitution as non-amendable. The first one is you can't amend the Constitution to prevent people from importing slaves before 1808. We had to give the slave owners 20 years to get enough slaves, and that could not be changed by amendment. The second thing is you can't have a per capita tax, and that was also to protect the slave owners, because the way to get rid of slavery was to impose a per capita tax on all the slaves. That would have put the slave owners out of business. So 2 of the 3 non-amendable provisions are designed to protect slave owners. The third non-amendable provision is you can't touch the requirement of equal suffrage in the Senate. So even if we wanted to have a constitutional amendment, we can't fix the Senate. The only way you can fix the Senate, there is a way to do it. I mentioned it in my book, but no one will ever do it. You can break states up into smaller states. So you could have a rule that said when you reach a 20-to-1 disproportion in one person, one vote, the state is automatically authorized, if it wishes, to break itself up into more than one state, each of which will have 2 votes in the Senate, as long as the state legislature can agree on boundaries. So California could break itself up into 2 states. New York could, Illinois could, Pennsylvania could, Texas could, and Florida could. Under a 20-to-1, you could do it on less, but if you just had the 20-to-1. So it is possible to minimize the dreadful disproportionate nature of the Senate by doing 2 things: making Puerto Rico a state, making the District of Columbia a state, and busting up some of the big states into smaller states that would each have 2 representatives. Only a founding generation could do that. And this generation doesn't have what it takes. They are not a founding generation. I just don't see it happening. So I think it's possible, but it's not going to happen.
So I had a question in regards to your earlier comment about President Trump kind of breaking the norms that we've had as far as presidential actions in the Senate not really checking him. Even before that, the idea of an imperial presidency had kind of started to take hold through still adhering to norms, but more of kind of worming its way through. So now that President Trump has kind of moved the Overton window as far as what is acceptable behavior, do you think that a more tactical, skilled, and maybe somebody that's more like less impulsive would be able to take advantage? Or is there a way that we can kind of put the genie back in the bottle now that he's kind of taken the cork away?
It's a good question. The question is, one of the things that I've lived through and you've all witnessed is the growth of an imperial presidency, a slow, accretal growth of an executive branch that has enormous amounts of power and that dwarfs the legislative or the judicial branches. In large part, it's because Congress gave away its power. Congress chose not to exercise its power. They couldn't wait to delegate national emergency power to the president, and now that's coming home to roost. I mean, Congress, it's not that Trump isn't making this stuff up. Congress created hundreds of national emergency exceptions in all the statutes that they passed, saying, yeah, you got to do this in case, unless the president says it's a national emergency, and then he can say what he wants. That's what happened with the travel ban. It's what's happening with the border wall. Congress has given the power away, and now it may be very difficult to ever get it back. But the question is a good one. Is there some way that we can somehow control the existence of an imperial presidency and start taking the power back? And the answer is absolutely yes. I mean, my book has a dozen suggestions that could snip, and when you're done, you really do have pruned the imperial presidency back to some sort of control. But the ultimate issue is whether the Supreme Court will have the guts to stand up to the president. Now, in 1952, when Truman tried to nationalize the steel mills in the middle of the Korean War on the grounds that we have fighting men on the ground. I need steel for bullets. So if you guys are going on strike, forget it. I'm nationalizing the mills. The Supreme Court said, absolutely not. Of course it's a national emergency, but only Congress can do that. You can't do that yourself. If that court had the courage to say no, this court does not have the courage to say no. This court knows only one word, and this, or 5 of them do anyway, and that one word is deference. Deference to the president. Deference to the president is what brought us Korematsu. Deference to the president is what brought us the McCarthy era. And deference to the president is what is bringing us the slow accretal growth of a presidency that can't be controlled. And so what we really need is, one, to beg the Supreme Court to put a little spine in its voting, and secondly, to have Congress start taking the power back.
All right, so on that note, I have to tell you one thing, is that we will have books for sale.
Books
over-
for sale,
or
yes.
available, and that you can get Bert to sign your book at this table when we are finished. And I want to thank everyone for coming, but most especially Adam. Thank you very much for being on the panel, and thank you so much for writing.
Thank you,
a very
guys.
important book.